What are some of the important things you need to know about doing a last will and testament? I'm attorney Vernita Williams. I practice law here in South Florida. And in this season of crisis, I'm getting a lot of phone calls about what are the important documents that a person needs to put together to make sure they have their affairs in order and they have appointed people that they want to assist them if they cannot handle their affairs on their own. So in this video, I want to talk to you about the last will and testament. And before I do that, I want to tell you the 8 basic things you should look at quickly, and then I'll get to the last will and testament. First, make sure you have a living will that says whether you want to be on life support. Second, the medical power of attorney, appointing someone to make medical decisions for you. Third, have a durable power of attorney for someone to make business and financial decisions for you. Fourth, a last will and testament. And if not a last will and testament, fifth, a revocable trust. 6, a joint tenancy deed. 7, a Totten trust or beneficiary designation card on file at your bank. And 8th, insurance. Now, everybody doesn't need all of these things, but you should consider all of them to make sure that you have properly put together your estate plan. Let's look specifically at the last will and testament. The last will and testament is a relatively simple document. A lot of people believe they can do their own. I encourage you, not for self-serving reasons, but just because I've seen some things in my time as an attorney. Do not try to do this on your own, please. You need a last will and testament, and I want to share with you some key things that you need to remember when you are doing your last will and testament. First of all, as I said, don't do your own last will and testament. It's not a good idea because there are many, many mistakes that can be made if you do not understand how to do it. The second thing, understand that if you do a last will and testament, you will have to go to court. This is not a document that keeps you from going to court like a revocable trust. If you do a last will and testament, your family will have to go to court in order to see to it that the last will and testament is carried out. The third thing I want to share with you is about 7 types of very common mistakes that people make, to make sure you understand that this is a very serious matter, and I would hate for you to put together something that ultimately is null and void. So make sure when you're doing a last will and testament, you have enough witnesses. I've seen documents prepared. I understood what the person meant, but they didn't have enough witnesses. The state statutes tells you how many witnesses you have to have in each state. In Florida, it's 2. Make sure the document is notarized. Make sure there are not inconsistencies concerning the will, like having different dates. Sometimes I've seen documents where there were several different dates in one document. So that suggests that perhaps the people weren't together when they signed it and witnessed it, and that makes the will subject to challenge. Another common area of mistake is failure to understand what you can and cannot do with homestead property. A lot of times people say, well, I owned this property before I got married. I'm going to will it to my children. Well, not so fast. Make sure you get a good understanding with an attorney about what you can do with homestead property. Another mistake area is creating conflicting documents. Sometimes people put on file with the bank, give this money to John, but they might put in the will, give the money to Brenda. Well, guess what? Even if the will was the most recently done document, the document in the bank is going to control who gets the money. So make sure you're not doing conflicting documents. Another common area of mistake is not including a guardian for minor children. If you have minor children and you draft a last will and testament, you need to say who you would want to be the guardian of that person if you passed away. Also, another very, very common mistake is listing a whole lot of personal items in the last will and testament. I've seen wills not prepared by attorneys where people list shoes, they list book collection, they list jewelry collection, they list paintings, they list gun collections, they list figurine collection. All of these different things. It's not a good idea to put those things in your last will and testament. There is a way to deal with those things, but not in your will. So when you're considering doing a will, make sure you go and you sit with an estate planning attorney that is experienced so that you can get a will drafted that will hold up in court. I'm attorney Bernita Williams. If you'd like to strategize more concerning your last will and testament, please call me or text me at 786-831-9483. Thank you so much for listening.